Hi everyone, Neama Rahmani, real lawyer, former federal prosecutor, president of West Coast Trial Lawyers, and Harvard Law School grad. So I'm going to be commenting on courtroom scenes from the series Suits.
Motion to substitute counsel, Your Honor.
On what grounds?
The grounds that he's a pussy.
What's that, Mr. Spector?
I was just wondering if he has a copy of his motion because we never got one.
So lawyers say all sorts of things to try to continue cases or to get out of cases. Now, more often than not, judges don't inquire. They rely on the duty of candor to the court. Lawyers aren't supposed to lie to the judge. Now, in this case, Harvey Specter had some information about this lawyer using the same excuse every time. Now, I don't think the judge would have indulged this back and forth as far as a family tree is concerned, and 5 years of making the same excuses. That would be some very good research, but Harvey Specter did a very good job and was able to get the lawyer sanctioned. So sanctions are a punishment that a judge can issue if a lawyer lies or they break any of the other ethical rules. So in this case, a $2,000 sanction is pretty serious.
Did Mr. Darby ask you to solve any problems for Hessington Oil regarding their pipeline and the EIR?
I decline to answer under my Fifth Amendment rights.
The right against self-incrimination.
So everyone in this country has a Fifth Amendment privilege against self-incrimination. That's a right to remain silent. So they don't have to answer questions if it may incriminate them. And this right is absolute, unless a witness is given immunity by prosecutors. If they do have immunity, then they can't be prosecuted, in which case there's no criminal exposure. Now, in one respect, this is not entirely accurate because normally, if a witness is going to invoke, the judge won't let an attorney keep asking questions that are going to elicit the right to remain silent. The witness will invoke and they will leave. And one other way this is accurate, when you're on cross-examination, you can ask leading questions. You can even make statements. And the classic is, isn't it true that da-da-da-da? It's not really a question, or you did this. Again, not really a question, but it's cross-examination. And you can cross-examine your own witnesses if they're hostile. But if they're not hostile, you normally can't use leading questions.
I worked as a waitress to supplement my income, but I don't see what that
And
has
how
to
much do you make now, Ms. Paulson? Somewhere in the six figures?
Yes.
It's quite an improvement on minimum wage plus tips, wouldn't you say?
What can I say? I'm very good at what I do.
And was shredding a document related to the Coastal Motors case that your firm tried years ago one of the things that you were good at doing?
Shit.
What the hell does he know about that?
All right, so there's a lot going on here, and importantly, we're talking about objections. So there's different types of objections that an attorney can assert after a question before a witness answers. And one way that this is entirely incorrect is when there's an objection, the judge has to rule on it. It's not a situation where the attorney objects and the asking attorney continues to ask the question or the witness answers. The judge needs to step in, do his or her job, and rule on the objection. If the objection is sustained, that means the witness is not to answer the question. So one thing you're seeing here from Harvey Specter is what we call a speaking objection. So normally an objection is just supposed to say the basis for the objection, the legal reason. So something like hearsay, argumentative, leading, very short statements of the legal principle that makes the question improper. You're not supposed to see a speaking objection because that's considered coaching the witness and potentially giving them the answer. So you see Specter saying, well, it's not illegal to do what she did. That's why the question's objectionable. Again, not a proper basis for the objection. Otherwise, this is a pretty aggressive cross-examination and something that the lawyer should have anticipated when they were preparing their witness.
According to the police report, the accident occurred at 8:53 a.m. That means you only had 7 minutes to get downtown in rush hour traffic.
Objection irrelevant.
I believe when I made the same objection, you told His Honor it was highly relevant.
Overruled.
All right, so this is a civil case. Looks like it's a car accident case, and the other party in the case doesn't appear to be represented, so there's no lawyer. So when you're a witness, you're not supposed to be the one objecting. Your lawyer is supposed to do the objecting, but obviously it appears this individual doesn't have a lawyer. So obviously what Harvey Specter is trying to do is show that the other party was late, he was speeding, and he's setting up the time of the auction and the time of the accident to establish that. That's all fair game. Now, if there's any type of settlement discussion, that doesn't happen at a sidebar, certainly not in the middle of a witness examination, and certainly not before the judge in the middle of the trial. Now, there sometimes are what we call judges that will help facilitate a settlement, but it's never the trial judge in a case, so that part is definitely not how it really works. Thanks everyone for watching me analyze courtroom scenes of Suits, one of the best legal series of all time. You can catch it on Netflix, and you can catch me by liking, subscribing, and ringing the bell for notifications.